Good afternoon, everybody. I am Amy Rizzo. I'm the marketing manager for Kelleher and Holland. Welcome to the third installment of our monthly employment law-focused Lunch and Learn webinars. Playing on our lunchtime theme, this session is entitled Safety in Every Bite, a lunchtime guide to OSHA compliance. Our webinar today is meant to provide a general overview of OSHA, what it is, what it requires of employers, what rights employees have, and how these regulations apply or do not apply to non-industry workplaces, such as office buildings. So before we get started, if you have a question at any time during the webinar, please type it in the Q&A question box located in your Zoom control panel. We'll try to get to all your questions live, but if we are short of time at the end, we'll follow up with you directly offline. Today, we have two presenters to discuss our topic. Our first panelist is a regularly featured speaker on our Lunch and Learns, Madeline Kelleher, part of our employment law group. She has experience facilitating OSHA interviews and investigations from the employer's perspective, and she has also handled personal injury claims involving the workplace. And also joining us today is Michael Morrison from our litigation team. In addition to also handling personal injury matters, Mike has experience navigating the OSHA regulations regarding workplace claims and injuries involving toxic substances, such as asbestos or other toxic chemicals. So panelists, you probably noticed that I have a lot of sweet treat images on the slides today. So I'm going to ask you the question of the day before we get started. Do you have a favorite dessert?
That's a great question, Amy. I would say my favorite dessert has to be key lime pie. How about you,
How
Mike?
about you, Mike?
I would say red velvet cake, cupcakes specifically, no
We've
doubt.
got a light sweet one and a heavier sweet one. Both are delicious treats. So I agree with both of you. So let's get started. Mike, I'm going to start with you. If you could tell us a little bit about what OSHA is.
Sure, thanks, Amy. Let's start from the beginning. OSHA is the Occupational Safety and Health Administration, which is part of the federal government. It's an agency that's authorized to inspect and examine the safety of certain workplaces in the private sector, such as construction, maritime, and general industry. As a bit of historical background, Congress created OSHA to ensure the safety and health conditions for workers by setting and enforcing safety standards and providing training, outreach, education, and compliance assistance. President Nixon signed the OSHA Act on December 29, 1970, and later enacted in April of 1971. Since the 50 years plus that OSHA has been around, it has helped transform America's workplaces in ways that have greatly and significantly reduced workplace fatalities, injuries, and illnesses. OSHA is part of the executive branch, specifically the Department of Labor. The OSHA Act requires employers to provide safe workplaces and to provide health protections for most private sector employers and their employees. And this, by the way, covers all federally covered private sector employers and workers in all 50 states. The OSHA regulations are massive. For those looking for a little light reading, the regulations can be found under Title 29 of the Code of Federal Regulations, or CFR. And they're divided into three primary subsets: general industry, construction, and maritime. Under federal OSHA law, employers are responsible for providing safe and healthy workplaces for their workers. Generally, OSHA sets forth specific standards that address hazardous activities and conditions in the workplace. All states in the United States must opt into one of three types of OSHA plans. The first is the federal OSHA program. There's also a separate state program that addresses workplace safety, referred to as state plans. And there's a hybrid program, which is a combination of the two, known as a hybrid state plan. Illinois, for example, is one of 6 states that has adopted a hybrid state plan, which is designed to supplement rather than replace OSHA by creating laws that specifically cover state and local government workers. So in Illinois, private sector workers and employers are still subject to the jurisdiction of the federal OSHA laws, but employees of state and local government, for example, are subject to the jurisdiction of Illinois state OSHA laws. So while the states have the option of adopting their own sets of occupational safety laws, state OSHAs, those laws must be at least as stringent as the federal OSHA laws. In other words, federal OSHA sets the standard, they set the floor of the minimum safety standards allowable, but states can choose to adopt more stringent standards. So that's OSHA in a nutshell.
Thank you, Mike, for that definition. So now that we know what OSHA is and what its purpose is, the question becomes then, do OSHA regulations apply to all employers?
I'll take this one. So with a few exceptions, generally yes. Under the OSHA Act, an employer is defined as a person engaged in a business affecting commerce who has employees, which is pretty broad. But I think, Mike, you might have had a few more things to say on this.
Right. The OSHA Act itself is pretty broad, as Madeline mentioned. And when you take that broad definition of employer combined with the definition of commerce, a private sector employer covered by OSHA is any business with one or more employees in commercial and non-commercial activity that is, quote, affecting commerce. So the scope of OSHA's coverage extends from corporate businesses to manufacturing to non-for-profit to agricultural and even private education. But there are situations where OSHA does not govern workplace safety. For example, if a business has no employees, they're generally not subject to OSHA. If a industry is already regulated by a separate agency or regulations, they are not covered by OSHA. For example, mining companies or nuclear power plants that are already governed by different regulations and agencies not under OSHA. Another exception, although not frequently seen here so much in Chicago, is if you are an immediate family member of a farm employer. All state government employees are not protected by OSHA. Rather, they are typically protected by the state-approved program, which has its own set of regulations that govern. As to what work environments OSHA applies to, OSHA defines the work environment as the establishment and other locations where one or more employees are working or are present as a condition of their employment. The work environment includes physical locations and the equipment and materials used by the employee during the course of his or her work. So the bottom line is that with a few limited exceptions, the OSHA regulations likely most definitely apply to your workplace.
Great. So Madeline, if I'm an employer, what are my responsibilities under OSHA?
So under the OSHA Act, this is a great question. Under the OSHA Act, employers have a responsibility to provide a safe workplace for their employees. Generally, they have to provide their workers with a workplace that doesn't have any serious hazards. They have to follow all OSHA safety and health standards, and they have to identify and correct all safety and health problems in the workplace. On top of these general requirements, there are also many primary responsibilities for employers that all covered employers have under the OSHA Act. I'll break these down into a few sections. So first, we have employers needing to communicate and train their employees. By using color codes, posters, labels, or signs to warn employees of any potential hazards in the workplace. They also have to establish or update operating procedures and communicate with their employees. Communicate these operating procedures to their employees. They have to provide safety training, and if there are serious hazardous chemicals in the workplace, they need to develop and implement a written hazard communications program and train their employees on the hazards they're exposed to and what the proper precautions are to take. So, second, employers must also report work-related fatalities and other specific types of injuries and illnesses to OSHA and must keep records of these injuries, illnesses, and fatalities. We'll talk about that a little more in a few minutes. Third, if OSHA performs an inspection on the worksite, an employer must provide the OSHA officers with the names of authorized employees who may be asked to accompany the OSHA compliance officer during the inspection. If OSHA then cites an employer with a violation, the employer must correct the violation by the deadline set by OSHA, post the citations at or near the work area that was involved, and keep them there until the longer of 3 business days or until the violation itself is corrected. And they also need to submit the required abatement verification documentation to OSHA to prove that they did correct the hazardous condition. Finally, all businesses with more than 10 employees are required to have a written emergency action plan. So businesses with 10 or fewer employees are still required to have an emergency action plan, but they need only communicate it to their employees verbally. Emergency plans contain information about evacuation procedures, floor plans and maps, exits, and the employee actions that need to be taken in case of fires, explosions, toxic chemical spills, hurricanes, floods, blizzards, and the list goes on. It should also describe additional responsibilities to be carried out by specific employees to ensure that each emergency is handled smoothly. For example, one employee could be designated as a monitor to make sure that everyone gets down the stairs safely and calmly and nobody gets trampled in the process. Some industries are also required to have additional plans, such as those for fire prevention, about personal protective equipment, bloodborne pathogens, fall protection, electrical safety, forklift operation, just to name a few. And again, it's critical to have someone in the company designated who will have the knowledge about and the ability to navigate through these requirements. Because failure to do so could result in significant issues for the company in light of OSHA's regulations.
Mike, let's talk about what happens if the OSHA regulations do not cover a specific hazard that's present in a workplace.
Sure. OSHA does not specifically address every hazardous situation that may be present in any given workplace. So when a specific OSHA recognized hazard is not covered, OSHA does have a catch-all provision that it can use to enforce safety compliance. As the name suggests, the general duty clause mandates that all employers and employees have certain general duties. OSHA has established regulations for when it may act under the general duty clause, and it has criteria that it uses to determine that. First, there must be a hazard. Secondly, the hazard must be a recognized hazard. The employer knew or should have known about the hazard is obvious, or it's recognized within that industry. And then the hazard must be one where it could or is likely to cause serious harm or death. And then lastly, the hazard must be correctable, because not all hazards are correctable. And the employer then must comply with that general duty. And for OSHA then to come back and try to assess a fine or a citation for a violation of the general duty clause, they have to prove a few things as well. Number one, the employer failed to keep the workplace free of that hazard. The hazard, again, was a recognized one. The hazard was or likely to cause death or serious physical harm. And there was a feasible and useful method to correct the hazard. Employers can and are frequently cited for violations of the general duty clause if a recognized serious hazard exists and the employer fails to take the steps necessary to correct that condition. You may be asking yourself, well, what types of situations are we talking about? Some of the more commonly seen violations for the general duty clause include such things as cell phone usage while driving, ergonomic hazards from typing too long or sitting in front of a screen, storing incompatible chemicals together, structural damage to buildings that create a hazard, workplace violence that goes unmitigated. So those are the types of things that fall under the catch-all general duty clause. So the bottom line is, if there's a recognized hazard at your workplace that's likely to cause serious harm and it could be fixed, the employer better fix it. Otherwise, don't be surprised if you get a letter from OSHA one day saying that you violated the general duty clause.
We've talked a little bit about employers, so let's talk about employees. What are their rights and protections under OSHA, Madeline?
So under OSHA, employees have rights with regard to safety and health in the workplace, including 4 main overall rights. One is to receive information and training from their employer about the hazards, the methods to prevent the harm, if any, and the OSHA standards that actually apply to their workplace. Another one is they have the right to receive copies of certain records related to work-related injuries and the testing for hazards and corrections that were made. Third, they can participate in any OSHA inspection and speak in private with an OSHA inspector. Another one is that they can file confidential complaints with OSHA and have their workplace inspected if the employee really believes that the working conditions are unsafe or unhealthy. Workers can also have the legal right to refuse to work in certain situations. Of course, the hazard while choosing to refuse to work must be clearly present and have a clearly present risk of death or serious injury or physical harm before the worker can refuse. Finally, it should be noted that the OSHA Act strictly prohibits employers from discharging, retaliating, or discriminating against any employee who elects to use their rights under the OSHA Act.
So back to employers for a little bit. Mike, what should employers do when an accident does happen? What are the steps that they need to take?
When an accident occurs in a workplace, there are a few initial steps that every employer should take. First and foremost, make sure that 911 has been called and that the injured worker is receiving the medical attention that he or she needs. Secondly, you should assess the situation and gather all the facts. Talk to all the witnesses, take statements if necessary, determine how this accident occurred. This will be critical down the road for a whole host of reasons, including if there's an OSHA investigation. Next, I would call an attorney, either your in-house counsel or an outside counsel, to discuss the situation, how the accident happened, develop a plan for your next steps to ensure that you're, number one, fully in compliance with what OSHA requires of you, and to prepare for a potential investigation that may be down the road. Then, if necessary, you should report that incident to OSHA. And there are a couple of criteria that require immediate action in that regard. We'll discuss that in a second. Those situations that I just mentioned, where a fatality occurs on the job site, the employer has 8 hours to report that to OSHA. If the accident results in a hospitalization, an amputation, or loss of an eye, the employer must report that accident to OSHA within 24 hours. Something to note here that if a fatal accident or fatal injury occurs outside the workplace, such as motor vehicle accident on a public street, on a commercial airplane, a train, a subway, anything like that, even though it's part of the employee's job, that does not need to be reported to OSHA, even though it's a fatality. So there's some nuance even amongst rules like this.
Madeline, Mike just talked a little bit about reporting. So what kinds of records do employers need to keep to fulfill these OSHA requirements?
Well, not only do employers need to report these injuries that result in fatalities, inpatient hospitalizations, amputations, or losses of an eye within a certain time frame, as Mike just explained, but OSHA also requires employers to report on every injury and job-related illness requiring medical treatment other than first aid on a detailed log of work-related injuries and illnesses. This must be kept on the worksite for at least 5 years. And in addition, for the 3 months between February through April of each year, employers must also post a summary of the previous year's log of work-related injuries and illnesses somewhere in the workplace where all employees can see it. This information helps employers, workers, and OSHA evaluate the safety of a workplace, understand the industry hazards, and implement worker protections to reduce and eliminate hazards, preventing future workplace injuries and illnesses. Now, some industries are exempt from those record-keeping requirements. Overall, there are 2 exemptions. First, it would be for companies with 10 or fewer employees. These companies must keep injury and illness records only if OSHA specifically requires them to do so. Second, it would be for establishments and companies classified as certain low hazard industries. That would be typically those such as real estate, finance, retail, insurance, and service sectors. But note that there can also be partial exemptions. So, for example, your company's manufacturing site may be required to comply with OSHA's record keeping requirements, but your company's headquarters could be exempt or partially exempt in each case. And this presents the question, how do you know if your industry is exempt or partially exempt? So to determine this, you can look at your industry-specific NAICS code on the US Census Bureau website. And then you will look up that code you found on the OSHA table on OSHA's website. You can see the URLs for both of these websites on your screen right now.
So Mike, how does OSHA enforce compliance with these regulations? And what sort of penalties do the employers face for non-compliance?
Well, when OSHA finds that an employer has violated their responsibilities, the agency typically takes pretty swift and decisive action. First, inspections are initiated without advance notice by highly trained OSHA compliance officers. These inspections are scheduled by OSHA based on a list of priorities, ranging from imminent danger, the employee suffered a significant illness, catastrophe, or death. There's been specific complaints from workers. There's been referrals from the federal, state, or local agency. There's a targeted industry inspection, or there's a follow-up inspection. So OSHA tries to prioritize its inspections based on severity. When an inspector finds violations of OSHA standards or other serious hazards, they may issue citations and fines. Citations includes the methods an employer must use to fix the problem and the date by which they must fix it. Employers have the right to contest any or all part of the citation, including whether the violation actually occurred. It's another area where involving an attorney who specializes in this area would be useful. Additionally, workers have the right to challenge the deadlines by which a hazard must be resolved. And appeals for citations are heard by the Independent Occupational Safety and Health Review Commission. OSHA also has what they call the Severe Violator Enforcement Program, or SVEP, which concentrates its resources on inspecting employers who have a history of indifference, so to say, in enforcing their OSHA obligations by committing willful, repeated, or failure to abate violations. In other words, repeat offenders get special treatment by OSHA. They don't want to be on that list. As far as penalties, Amy, an employer that receives a citation for a serious breach of OSHA can face penalties up to $7,000 per violation. Employers that intentionally and repeatedly violate OSHA's standards can face penalties of up to $70,000 per violation, with a minimum violation of $5,000. OSHA also can request jail time for employers, typically the owners that commit serious offenses. For instance, if an owner commits a willful violation that results in the death of an employee, makes a false statement or representation or certification in any application or document, and gives unauthorized advance notice of an OSHA inspection to allow their employees to, quote unquote, fix the issue before OSHA comes in. Those are all big no-nos, and you could wind up behind bars. So the bottom line for all this is OSHA likes rule followers. They don't have the ability or capacity to play Big Brother, and they don't really want to. But for those employers that don't want to play by the rules, especially the repeat offenders, OSHA is definitely keeping its eye on you. So know the rules, follow them, and you'll be in good shape.
Thank you, panelists. That was a lot of great information and insight in a short amount of time. So I thank you for presenting that today. Remember, attendees, that attorneys at Keller and Holland are available to assist you or your company in ensuring compliance with OSHA obligations. We can help you avoid citations and fines and create a safer, more compliant work environment, because really that benefits everybody. There are a lot of specifics we could get into with OSHA, and we have a little bit of time left to answer any audience questions. So just a reminder, if you would like our panelists to answer your question live, go ahead and type it in the Q&A question box that's located in your Zoom control panel. And I see we have a couple of questions coming in. Let's see, the first question. Do the OSHA regulations apply to a home office in a work from home or hybrid work situation? That's a great question. So Mike, would you like to take this one?
Yes, and I was hoping that this issue would come up today, given the widespread work from home landscape, which likely will continue to be the norm, I think, for at least some companies for the foreseeable future. I think it's important to remember first that under the OSHA General Duty Clause, every employer has a general duty to furnish their employees with a workplace that is free from recognized hazards that are causing or likely to cause serious physical harm or death. So let's start there. The OSHA Act does apply to any workplace, including a workplace located in an employee's home. All employers, including those that have entered into work from home arrangements with their employees, are responsible for complying with OSHA. But OSHA, I think in its wisdom, has made clear that an employer is only responsible for ensuring that an employee has a safe work environment, not that the home itself is safe. So an employer is only responsible for ensuring that the employee is a safe workplace within the home, not that the home itself is necessarily a safe place, if there's a distinction there. The employer is responsible only for preventing or correcting hazards to which employees may be exposed during their work hours while in a designated workplace. But in situations where the employer has provided work materials to the employee, for instance, high-powered tools, chemicals that are necessarily part of that employee's job, the employer needs to ensure that the employer who has provided those materials does so in a way that doesn't pose any hazardous risk or harm to its employees. So that's a little bit of a different situation than what we think about from work from home, the typical sense of working at a desk and working on typing or word processing, answering the phone, those types of things. In those types of what you would call, I guess, typical work from home situations, the employer actually has very little responsibility for making sure that the employee is safe. In fact, OSHA has issued some specific guidance for home offices. OSHA has stated that it will not conduct inspections of home offices for any employees. OSHA will not hold employers liable for the home offices of their employees. OSHA does not expect employers to inspect the home offices of its employees. That being said, if OSHA does receive a specific complaint regarding the safety of a home office, OSHA will let the employer know about the complaint, but it's not going to strictly monitor and follow up as it would in a normal workplace environment. I think OSHA is pretty pragmatic in this regard and realizes it's simply not feasible for employers or the agency itself to police home offices in every situation. So while there are some exceptions, to answer the question, Amy, while there are some exceptions, work from home situations and work from home offices poses really little additional responsibility or liability on most employers.
Great. It looks like we've got one other question that has come in. Is there any difference in the rights employees have as it relates to OSHA if they are part of the H-2A or H-2B work programs, and any difference in the responsibilities that the employer has?
To answer that question, workers, regardless of immigration status, are covered and regulated by OSHA. So there wouldn't be any difference if it's a United States employer. There wouldn't be any difference in the responsibilities the employer has towards its workers, because this is for all workers, no matter the immigration status. And then for the rights the employee has, that same thing. If they're working for a United States employer, then they're covered by OSHA and they have the same rights to report any serious hazards or violations that they see in the workplace, or any of the other rights that they have that I, mentioned earlier. Hope that answers the question.
For more information on our employment law services or any of our other practice areas, visit kelleherholland.com or send us an email to attorneys@kelleherholland.com. Kelleher & Holland's Employment Law Lunch and Learns are prepared for the general information of clients and friends of the firm. It is not intended to provide legal advice with respect to any specific matter, nor is it intended to create an attorney-client relationship. Under rules applicable to the professional conduct of attorneys in various jurisdictions, this may be considered attorney advertising material.